Chuck, thank you so much, sir, for coming on the program tonight. Good talking to you.
Always a pleasure to talk to you, Cam.
And, there is so much stuff going on in California. I don't know how you keep track of all of the cases that are currently underway in the California courts. We were talking just a couple minutes ago. You got the Parker case, the Jackson case, the Nordyke case, the Peruta case. Then you've got the cases with the Center for Biological Diversity that you guys are involved in. When do you sleep, Chuck?
That's just California too. I had to do an Excel spreadsheet to track all the cases going on across the country. NRA is involved in things in Texas and Chicago and Washington D.C. And then there's other groups that have their lawsuits going, and then there's just a whole bunch of different individuals who, in some cases, it's not such a good thing that they have their lawsuits going.
Yeah.
But there's a lot of lawsuits out there. The Second Amendment jurisprudence is developing. Yeah, we're going to get there's a lot of cases in the works, and we're going to get a big, I think, flurry of decisions coming down in the next 6-8 months.
I think you're right. One of them is going to be the Nordyke decision, right?
Yes, that's a big one that we're waiting for, because if nothing else, Nordyke should resolve one of the issues that the gun ban lobby's been trying to push. They'd like to keep the Heller and McDonald decisions inside your home. They don't want the Second Amendment or the right to self-defense to apply outside your home. So they've been trying very hard to argue that Heller doesn't apply outside the home, and I think Nordyke would probably resolve that issue, which will be a big step in the right direction.
Yeah, because we saw the Maryland Court of Appeals yesterday, in essence, say that very thing. And they said, well, the Supreme Court didn't specifically say that the Second Amendment applies outside of the home. Now, I think if you read Heller, you get the understanding, at least I get the understanding, that in fact, they are talking about a right to keep and bear arms not only in the home but outside of the home. There's the line about longstanding prohibitions on carrying firearms in sensitive places should not be construed to be overturned. But nothing. I mean, to me, Chuck, if you're going to talk about the prohibitions against carrying in government buildings or schools, we're not challenging those. That leaves open a lot of other places in this country where we can carry.
Yeah, it's ludicrous to claim that. Look, there's a right to keep and bear, not just bear inside your house. And historically, when at the time of the founding, we certainly were not limited to keeping and bearing our firearms in our home. Concord Bridge is not inside your home, but it's. Unfortunately, there are some courts, and doubly unfortunately for me, a lot of them are in California, that want to read these laws, that want to read the case very narrowly and try and restrict this right. People got to realize just because the Supreme Court said something doesn't mean that those who have been fighting against the right to self-defense and the Second Amendment for all these years just roll over. They have very good lawyers. They have, deeply entrenched political and philosophical beliefs. They're all wrong, but they still believe them. Mm-hmm. And, we're up against that, which is one of the reasons why California is often not the best forum to bring a lawsuit. Because with the Second Amendment now, you've got a national civil right that you can bring a case in any jurisdiction, and it establishes national precedent. So NRA's lawyers and headquarters is very careful about considering things from that national perspective before they go diving in somewhere.
Sure. Now, when you look at the California cases that are out there right now, the Parker, the Jackson case, the Peruta case that we talked to you about recently, the Nordyke decision we just mentioned, and then the environmental cases where the NRA has been filing briefs with challenging the Center for Biological Diversity. What case, Chuck, do you think we're going to see a decision in first? Or do you think that all of these are going to be coming in right around the same time?
No, I think we're going to see Parker first. Parker is the challenge to AB 962, and that's not even a Second Amendment case. It implicates the Second Amendment, but it's a challenge to California's ban, the new law that bans the mail-order shipment of handgun ammunition, and it defines handgun ammunition as ammunition that's principally used in handguns. Well, if you think about that for a minute, how the heck is anybody ever supposed to know that? I mean, there may be some calibers that you might commonly think are used in handguns because that's what you see at the range. But it's a big world out there, and there's a lot of different cartridges and a lot of different firearms that fire those cartridges, and can somebody really say that 51% of any given cartridge is fired in a handgun versus a long gun across the globe? So our challenge is the definition of handgun in that statute is unconstitutionally vague. We'll be in court on January 18th for a trial in that case, and I have my fingers crossed. Due process vagueness challenges are always tough to win. But this is the last case standing, so to speak, challenging AB 962, because the other cases, one of which was a federal preemption argument, were dismissed as moot, which we're all sort of confused by as we try and figure out what the judge's rationale was, because his order was only about a page and a half long. So they could be refiled. But we're going to see something on January 18th, and that law kicks in or is scheduled to kick in on February 1st. That's why you're seeing Cabela's and Midway and all the ammunition suppliers are all saying, your last chance to mail order into California is now. So I expect they're getting a lot of orders in anticipation of a possibility that handgun ammunition, whatever it may be. But most of the suppliers are just stopping from shipping any ammunition into California by mail. So all your internet and mail order sales are closing down for ammo on February 1st unless we get lucky in that lawsuit.
All right. Now, speaking of ammunition, I guess the last case, we'll have to have you back on again talking about Peruta and the CBD cases because those are fascinating as well. But I got to ask you, we're talking about ammunition. There's another case in California challenging San Francisco's ban on quote-unquote offensive ammunition as opposed to defensive ammunition.
Yeah, I love this one. This is the Jackson case. And it really underscores, first of all, it underscores how smart the NRA was in picking that case, because that case is in the home. That, if you think about it, that would really be sort of the next logical step in a Second Amendment, in developing a Second Amendment jurisprudence. You had Heller. That was in the home. There was no exception for self-defense in Heller. So your gun had to be locked, and there was nothing in the ordinance that said you could unlock it to defend yourself. San Francisco's ordinance has sort of a watered-down provision where you can carry the gun around, but it's got to be locked 90% of the time, and there's nothing that expressly says you can take it out. But they also passed an ordinance that says you can't buy any ammunition that's considered offensive by them, and that's not defined either. So we're challenging that on vagueness grounds as well. But it's also a matter of, they plainly think that Glazers and Plus Ps and Magnums and calibers like that, cartridges like that, are considered offensive, which really tells you their mindset is that you have to use some kind of less lethal ammunition in defending yourself, and that's the kind of thing that makes firearm trainers, use of force experts, roll their eyes and slap their foreheads, because there's no such thing as shooting to wound when you're in a life and death situation. This is just not the way you defend yourself. So,
yeah, absolutely.
What's coming up is an argument about what self-defense means and what you really should have a right to be able to do to defend yourself. And some of these cities are going to claim that you can't use deadly force. So it's fascinating, actually, and we're going to wind up going back to common law again and also I expect there'll be a lot of expert testimony about what force is really necessary to defend yourself, because it's not shoot to wound. There's not a police department in the country that trains their officers to defend themselves that way.
I remember in New York last year there was a city council bill that would have required the NYPD to quote unquote shoot to wound, and it was laughed out of the city council in New York City, which is saying quite a bit. But you're saying that this is the gun control advocates are going to try to make this the standard for you and I acting in self-defense.
Yes, they want to give you a very limited right to self-defense. First, they're going to try and keep it in your house, and then they're going to try and make it so that it's very, very limited. So, for example, in that Peruta case in California, they argued, and the court bought it, and it's on appeal now, but the court bought that you could carry a gun around unloaded and unconcealed, and only when you are in immediate grave danger In other words, you're about to die
Yeah.
or at risk of being about to be killed, then you can load it. So, consider a revolver. But people who don't practice with firearms all the time is probably carrying a revolver. Consider how long it takes to load that kind of a gun, even with a speed loader.
Sure.
That's the kind of restriction. They want it to be. They want it to take so long that basically, you don't have it's just not effective. I mean, walking around with an unloaded firearm and counting on having the time to be able to load it when you're under attack, it's a good way to get yourself, hurt or killed.
Yeah, absolutely.
But so that's the kind of debate we're going to have in a lot of these cases, I think.
All right. Well, Chuck, again, I'm glad you could join us tonight. And, let's touch base at some point next week so we can talk about the rest of the cases that we didn't have time to talk about this evening.
I'm at your service, Cam, anytime you need me.
All right. Thank you so much. So we'll talk to you soon.